Welcome, everyone. I hope you and your families are well despite the public health crisis we are facing right now. Please raise your hand on the control panel if you can hear me. Okay, I only see a few hands. If you cannot hear me, please log off and try to call back again because the circuits are busy due to the high volume of calls and use of control tech at this time. We also asking you to join. Okay, I can see hands right now. That's great. We asking you to join the webinar at 1:45 because and that way you can join without any problem to the webinar. Thanks for joining us today again. My name is Vivian Cristino, and I'm one of the capacity building specialists at Housing Action Illinois. Housing Action is a statewide coalition of more than 160 organizations, all working to protect and expand affordable housing and end homelessness in Illinois. Today, we are partnering with Legal Aid Chicago and Lawyer Committee for Better Housing to present this webinar on rentals, foreclosures, and bankruptcy court in the time of COVID-19. First, I'd like to thank today's presenters for their generosity. We are very grateful to them for sharing their time and experience with us. All three attorneys, and between them, they have decades of experience working on issues related to housing. Daniel Lindsay is the director of the Consumer Practice Group at Legal Aid Chicago. Legal Aid Chicago provides free legal service assistance in civil case to people living in Chicago and suburban Cook County. Sally Robinson is an state attorney at Lawyers Committee for Better Housing, and Eileen Flanagan is a senior attorney at Lawyers Committee for Better Housing. Lawyers Committee for Better Housing provides free legal and support these services to improve housing stability for lower income renters in Chicago too. So before I turn over to the presenters, we need to cover just a little housekeeping. So a record version of this webinar will be available for download to our website. If you have any questions during the presentation, please type them into the question box in your GoToWebinar control panel that you have on your right. I will bring them up during the presentation, and we will also have time for questions at the end. Also, you have in your control panel 5 handouts that I invite you to download to your desktop. And don't worry if you are just calling in and you don't have access to your desktop screen right now, or you are from your phone. We are going to post with the webinar recording in our website, so you are going to have access as well. So now, without further ado, we'll turn the time over to Daniel Lindsay. Daniel?
Thank you very much. Thank you, Vivian. So welcome everybody to this webinar. As Vivian mentioned, this is a collaborative effort today, not only between Housing Action Illinois and us, Legal Aid Chicago, but also Legal Lawyers Committee for Better Housing. So approximately the first half of the webinar, I'll be talking about COVID-19 updates for homeowners, and then the second half approximately will focus on protections and information relevant to renters. So if you have any problem hearing me, please do send in a little question or comment. And if I don't see it, then Vivian, you'll see it and you'll let me know. But let me go ahead and get started. So I wanted to start with, so already I'm having a little problem here, moving my screen. Sorry, let me,
go down and your left side, you're gonna see your click, or just go with the computer buttons and just move forward one.
Yeah, my computer buttons aren't doing it for me. I apologize to everyone. Obviously, we're all operating on different systems these days. I'm home remotely with a laptop that I just got a few days ago from work, so it's different from the one I have at work. And I'm trying to find, well, maybe that'll do it. With next looks good. All right, well, we'll make it work here somehow. So anyhow, I wanted to start by letting people know, or reminding people, if they do know, that the organization where I work, Legal Aid Chicago, serves low-income individuals and really a lot of other vulnerable populations, older folks, people who are disabled, survivors of domestic violence, veterans, etc., in the Cook County area. And part of what I want to do today is just to say, hey, we are open for business. Like most people, our office is physically closed, but we have 150 staff working remotely from home, and doing a lot of stuff digitally. And we are taking new clients through our phone systems. So bottom line, please keep us in mind if you have potential clients in the Cook County area. Our 5 practice groups are listed here: immigrant and workers' rights, public benefits, children and family, housing, which is rental housing, which for us it means focusing on subsidized housing, as well as consumer, which is the area that I specialize in, which is why I'm here today talking to you about homeownership. But we also do bankruptcy and debt collection issues, and I'll be talking a little bit about those as well. So we're open, and you are able to refer clients to us. And I apologize for this kind of unseemly little text you're seeing, but that's the only way I can figure out how to advance things. So that's what we're going to do. So if you do have clients to refer to us, this is the contact info sheet. I said at the beginning, we serve all of Cook County. And don't worry too much about income guidelines for referrals, because we have a lot of categories, again, like a number of seniors, disabled, veterans, domestic violence survivors, whom we can represent at much higher guidelines than the normal federal poverty guidelines. If you have a very specific referral for somebody in the homeownership area or another consumer area, or want to reach out and consult me, I've put my name, phone number, and email address there. If you have a client where it's more just of a soft referral that you want to send them to Legal Aid Chicago, or on a non-consumer matter, I've got our number there. We also have online intake accessibility through Aleo, and the website is there for that. And I also want to highlight to please continue to check out our website itself, legalaidchicago.org. We are putting up a lot of content. A lot of the kind of things we're talking about today is content that you would find on there, and we're updating it regularly. Obviously, things are changing daily, and new government programs and changes to government programs and court schedules are going to continue to come out. So we're going to do our best to continue to update those things on our website. And that reminds me to say that even today, what we're presenting to you is sort of snapshot, or maybe information that's going to be relevant over the coming weeks, maybe in a few instances over the coming months, but things are obviously going to be changing. So just to be aware of that, we're doing our best to give you what's the current situation today. So let me begin by, and again, I'm focusing on homeownership issues. Let me begin by talking about court closures and delays that relate to homeowners. I apologize here because, of course, we work in Cook County, so that's going to be some of my focus, and even Chicago specifically. Those of you who are listening and who are practicing or working outside of Cook County, you're going to need to consult with local sources for the variation on that theme that applies to your area. So state court, again, Cook County at least, there's an order that stays all matters for 30 days. And in many of my slides, you'll see a URL at the bottom. So that's just a URL which would take you to the appropriate order that I'm talking about. So all matters are stayed for 30 days. That includes all foreclosures, all foreclosure court dates, judicial sales, orders for possession that might be entered to vacate somebody at the end of a foreclosure case. There are provisions for filing emergency motions set forth in the order that you can access through the URL at the bottom. And again, yeah, for other counties, you're going to need to check that county's website. I looked at a couple last night, and some counties are just putting a little note on their county website saying everything stayed for 30 days or, stayed until further court order. So everybody's taking the same approach, just with slightly different, variations. So federal court, I want to mention, because there are still, a number of foreclosure cases that are heard in federal court. So we're involved here in the Northern District, which does cover a much larger part of Northern Illinois than only Cook County. So there are some foreclosure cases heard in district court and the trial court. And by court order, all dates in the district court are continued for 21 days. And there's the URL for that. It strikes me that, 21 days doesn't seem like very much at this point. I would not be surprised at all if we don't see further continuances, but that's what we have for now. Bankruptcy court I mentioned because we do a lot of bankruptcy cases at Legal Aid Chicago, and keep that in mind if you have a client or there's potential referral or you want to consult us. We do a lot of bankruptcies to try to save homes. Bankruptcy court is really the only court that's staying open. I mean, they're physically closed to all but core staff, skeletal staff, but they are continuing to hear matters on all the judges' court calls in bankruptcy court telephonically. So it's interesting. There's a court order. Again, the URL is at the bottom here. If you're interested, you can look at it. If you have any connection with bankruptcy court, what you have to do is sign up for this thing called Court Solutions, and then you can connect telephonically, and there's different dates for the court cases that are set forth in that order. So we are actually going to court in a sense, telephonically to bankruptcy court. So mortgage foreclosure relief. Kind of self-evident, but I think always worth reiterating in any context, including the current one. Contact your servicer. You know how homeowners can sometimes be. They're afraid, they're concerned, whether it's in normal times when they lose a job and can't afford the payment, or perhaps in times like this, and they kind of bury their head in the sand, or they feel like they'll get in trouble if they reach out to their mortgage company. And it's really the opposite. People need to reach out. And many servicers, by virtue of the programs I'm going to talk about the next few slides, are offering some form of relief now, or either being required to, or probably more and more will just do so on their own. So you need to reach out to your servicer, and this is just some common sense information here about doing that, and you want to encourage your people that you work with, your homeowners that you work with, to do that. Or if you're a housing counselor, reach out, three-way conference call, with the homeowner and the servicer yourself. Sorry, there we go. So again, as in normal times, if you're a housing counselor or working with somebody who has a mortgage and you're trying to assist them, you want to one of the first things you want to do is try to find out who owns their loan, or backs or insures their loan. And many times you can find that out by looking at the mortgage document if they have it, or if you're able to look it up on the Recorder of Deeds website. You can also just find that out from the servicer. There are a couple of links here to websites where you can go to see if your loan is insured by Fannie Mae or Freddie Mac. That's still obviously a very large portion of the mortgage market. And so you want to find out, first of all, if the client isn't sure. You want to help them to find out, who is it that actually, owns or backs or insures my loan. So if it's an FHA insured loan, which includes reverse mortgages, otherwise known as HECMs or home equity conversion mortgages. So either just a plain vanilla forward mortgage that's FHA insured, or a reverse mortgage, which 99% of the time is in fact backed also by HUD. In both of those cases, as you can see, no foreclosures or foreclosure sales for 60 days ending May 17th. So almost 2 solid months of just complete sort of putting on ice any foreclosure processes. In addition, a hold on all evictions from such properties. And finally, FHA servicers are supposed to, begin working now and through the next couple months to figure out kind of what happens next, and hopefully, we'll give a greater measure of loss mitigation at some time, if and when hopefully we get to sort of over the worst of this and back to the point where people are, resuming their lives more normally. If it's a VA loan, very similar. The language is a little different. The VA strongly encourages loan holders to establish a 60-day moratorium beginning March 18th, which would thus also go to May 17th or thereabouts. And I don't know yet, but I think probably most, servicers of VA loans are going to go along with the program and also essentially honor a moratorium of 60 days. Now, for privately held mortgages, again, most are going to be Fannie or Freddie, if you've identified that by doing one of the lookups from the prior slide. Again, you've got a 60-day suspension, and it applies both to residences, second homes, and investment property, so you don't have to sort of worry about making the distinction between those various types of property. Obviously, it has to be, property that's not abandoned. Again, contact your servicer. Impacted borrowers can request forbearance for up to 12 months, and with no late fees during that period of time. So, that's probably not going to be everybody, but if you've, lost your job or seriously lost a significant amount of income, then probably you're going to be able to get a forbearance plan like that. And toward the end there, it says services are not required to obtain documentation of a hardship. So again, it should be easier without going through the usual kind of rigmarole that sometimes happens with providing documentation ad nauseum to get this kind of relief. And that's just a slide that tells you some places you can go to look at that information in more detail, and then a couple of numbers at the bottom that are out there. If your servicer's not playing ball and you want to try to get some regulator assistance, enforcement, compliance, there's Fannie and Freddie numbers there. I have a feeling if you call those numbers, you're probably going to have to be prepared to wait a while. I haven't done it myself, but I'm guessing those numbers are going to be called quite a lot in the coming weeks. And just to throw one quick thing in, so Fannie and Freddie are also offering relief to multifamily property owners with mortgage property, but specifically only if they themselves suspend all evictions for renters unable to pay rent due to the impact of the virus. So this is kind of a good thing, a win-win for both the property owners and the renters, the property owners, but sort of important to help get the word out because multifamily property owners may not know this or may be confused. And again, there's a URL for that at the bottom. That actually kind of brings me to the end of my focus on homeownership. I wanted to add some stuff because we do consumer work broader than just for homeowners. I wanted to focus on some other issues as well. And I mean, the next slide is utility debt relief. And of course that does affect homeowners as well as renters. So, but I'm shifting a little bit here. So I thought I'd pause for a moment, see if there are any questions. Vivian, if anybody had any questions, let me know.
Okay, I unmute myself. Thank you, Dan. So I have only one question, and I think that one was at the beginning of your presentation. Somebody was asking about if there is a specific time frame for the 30 days stay.
Well, it was issued on, I believe, March 17th, 16th or 17th. So so it would be 30 days from that. I believe it goes to like April 15th or April 16th for the state court for Cook County. And then what's happening that's good is, because we're already seeing this, postcards are automatically going out, resetting dates for cases. So hopefully, the parties to those cases, I mean, they should kind of figure out what the 30 days is, the continuance, and just be prepared to maybe have a court date at that time. But they should also be getting postcards setting the new court date.
Okay, thank you. Another one is, what about deadline to file answers and appearance to cases that are already filed?
Well, that's a good question. You know what, I'm gonna punt a little. I'm gonna say it probably depends on what kind of case it is, because in Cook County, at least, there's different divisions. So like foreclosure cases are all heard in Chancery. So you'd have to look at the Chancery court order that I gave the URL for. But if you're a defendant in like a debt collection case, where a credit card company or a landlord or somebody is just trying to get money from you, then you need to look at the orders that pertain to municipal division. There's a whole bunch of different orders in Cook County, at least. So you kind of just have to go on the website where they're all available and look and see, depending on what the case is. But in one way, shape, or form, everything, I think, is being accommodated and put off for at least 30 days. So, especially with the city and now the state stay-at-home orders, there's no way that defendants should be penalized if they don't run down to the courthouse thinking they need to file something during this time. They may not even be able to, because for the most part the courthouses are closed. So I think check the local order for whatever type of case it is you're talking about, and then I think just be prepared to act, like as soon as possible when things open again. And if people, like defendants in cases, homeowners or other kinds of debtors, run into problems, we certainly expect to be very busy when things reopen, helping people deal with problems if needed, if they run into obstacles where people are not giving them the accommodation that they should be giving them.
Hey, Dan?
Sorry.
Dan?
Yes, go ahead.
Can I interject something? So this is Aileen. I just wanted to touch base on the chief judge order that was entered in Cook County. And I think there was this suggestion that other deadlines within the case are still in play. So discovery deadlines and things like that aren't altered by this continuance, this general 30-day continuance. So if you are under some kind of obligation to file an answer, and if you can do that, I would proceed cautiously and continue to act within the guidelines and the requirements of the deadlines in the case, unless, like Dan recommends, you can see an order that contradicts that. So, sorry.
Fair enough. All right, let me just move on to utility debt relief real quickly. Again, basically, ComEd for our area says no disconnections or late fees. Sorry, there's a misspelling there. Through May 1st. People's Gas, same thing, no disconnections through April. And the same with the water department. So everything's kind of extended. There shouldn't be any issues, with this kind of debt at least through May 1st. And in terms of some other debt relief issues that, again, may or may not apply to homeowners, may apply more broadly. This first one, of course, applies to homeowners, and this is good and important, and just came out a day or two ago. So the treasurer has stated that the annual property tax sale, which as you all probably know, normally takes place like May through July sometime, it will be postponed to be reset at some future date. So so people have sort of a stay on having to deal with catching up on property taxes to avoid the annual tax sale. As far as broader debt collection efforts, so I mentioned a few minutes ago, if you're a defendant, like in a credit card case, unfortunately, there's no mandatory stay at any level yet that I'm aware of. Some legislators were trying to get that included in the Federal CARES Act that was just passed, but it's not there. So far, all that I'm aware of are sort of debt collection industry standards, recommendations, telling the members of their industry, of the trade groups, to be more accommodating and suspend collection activities as required by local court guidelines, which, isn't really adding anything that's not already there. So I guess I would say people probably are going to be able to get the accommodations that they need. They may still face some debt collector harassment, but hopefully it won't be quite as bad as usual during this time. On the student loan debt front specifically, that I mentioned here at the end, things are actually a little better. So at the federal level, the Department of Education has stated that for all federal loans, there'll be a suspension of collection actions, including garnishment and tax refund seizures. I can't recall if that's for 60 days or just indefinitely, but at least for 60 days. There is a $2 billion refund of offsets. These were offsets that were in process on March 13th. And so really over about the last 2 weeks, student loan debtors who had tax refunds seized to the tune of $2 billion, that's supposed to be refunded. And that's over 830,000 borrowers. So that's big. That's a good thing. And as far as ongoing accounts, federally held student loan debtors don't have to make any payments in the next 60 days. There'll be no penalties or extra interest added. And, the federal government can't, at least as easily, tell or legislate what private collection agencies do, but they've encouraged them to halt proactive collection activities, which I think they will do.
Daniel, can we
Yes.
ask, a couple questions? We have a lot, but there is one
Okay.
about when you refer about the 30 days, is business days or is, the whole month 30 days period? And
Calendar days. As far as calendar days, as far as I'm aware, all of these 30 days, 60 days, it means calendar days.
Okay. And what happens if a client is using PTO time as a hardship? They are no unemployment yet. What should they do before they run out of the personal time? I think it's that one, PTO time.
So I'm sorry, I don't quite understand the
So
question.
let's see if somebody can clarify that one. Somebody just saying is, I'm getting individuals calling saying that with several banks forbearance is not being offered. They are only, okay, hold on. I'm getting individuals calling saying that with several banks forbearance is not being offered only a 2-month deferral with all payments due on the 3rd month. And so the suggestion is call Fannie or Freddie Mac?
Yeah. If it's a Fannie or Freddie loan, you could go back to those numbers that were on that slide and sort of try to escalate if necessary.
And when a
Yeah.
customer is being told they can get 3 months forbearance, but all the money is due on the 4th month, this is the same case. This is the help.
Well, I don't think that's at all in the spirit of what
Yeah.
I've read is supposed to happen. I mean, at the end of the forbearance period, there's not supposed to be the sense that, okay, everything we forbore, you immediately owe. So again, I think you're going to have to fight that fight probably down the road in 3 months, and then escalate if necessary. Again, work with housing counselors or refer to us, legal aid, or another agency that does this kind of work.
They say
All right.
they can still e-file the foreclosure online through the ODAC.
They're not supposed to be.
Oh, no? Okay.
They're not supposed to be filing cases right now.
Oh, okay.
Yeah.
Okay, we can just talk about the other questions.
Well, at least, all right, let me put it this way. At least again, you have to go back and look at which category of mortgage it is, but at least for the ones that are covered by those various categories, FHA, VA, Fannie, Freddie, they're not supposed to be filing new foreclosures right now.
Huh.
So a lot of this, we're going to have to sort it out later, and obviously there's going to be a lot of non-compliance and fights that we have to fight further down the road. All right, I want to wind down because I want to pass the torch to the baton to the LCBH folks to talk about renters' rights. I just have 2 more slides. I'll do them very quickly. I mean, the federal bill, I think was just signed, or is going to be signed today, or tonight or tomorrow, something like that. But it looks pretty clear that the final terms are along these lines. I just threw up a couple of the headlines here of money coming to individuals and to families, enhancements to unemployment benefits. The third one is extended ability to file a complete bankruptcy. So I don't really want to get into the weeds on that, but it may be the kind of thing where people can save their homes because they could do a bankruptcy that might not have worked previously. So again, we do bankruptcies. So when people are maybe facing losing their home and want to look at bankruptcy, there may be some extra tools that we can use there. There's some tax breaks coming, extra charitable deduction, of course, money for cities, municipalities, hospitals, medical testing. The second to last one there, some of you may be interested in and may not have heard about yet. There's going to be a huge amount of money available for small businesses, which normally does not include nonprofits, but under this bill, it will include nonprofits. And that money is intended to help keep people on your payroll and keep paying them for, I think, up to either 3 or 4 months. And then those loans can be forgiven if that's the way that the money was used. So that's, anybody in a nonprofit or small business or working with them, that's worth looking into as this rolls out. And of course, I couldn't help put in 0.5 billion. That's wrong. It's 0.5 trillion, $500 billion slush fund for larger businesses. Hopefully that will be used wisely and with discretion, and that was what some of the fighting has been about in the last few days. So I think there are at least some more protections in there for using this money, not just as a willy-nilly slush fund for connected, business owners. My last slide is just to say real quickly that, as we like to say in the consumer practice group at Legal Aid Chicago, fraud never sleeps. So of course, there are many scams already out there having to do with, taking advantage of people's fears and vulnerabilities during this time. It seems like a crisis like what we're experiencing now, brings out the best in people and the worst in people. So look out and help your people look out for these scams. I've already seen a couple of these. Fortunately, have not succumbed to any, but I passed a handout along to Vivian. So this is just a quick list, but the handout I gave to Vivian has more details on these kinds of scams and just very common sense, tips for trying to avoid them. And with that, I'll see if there's any more questions, because I think that's my last slide before I pass it on.
We have more questions, Daniel. Thank you so much. I reminded people, you on your control panel, you have all the handouts. You have 5 handouts there, and of course, it's included the COVID-19 scams, the lockout, the special order, and foreclosure information, resources for immigrants, etc. I have a couple more questions before we move on with Eileen and Sally. And it's
just a couple, because I don't want to take all their time, but yeah, maybe we can do a couple.
It's about the back taxes. So if you owe back taxes, will they take your check from the government, and also you when the government will take your stimulus check?
So yeah, I think you're asking about the money that's coming from the federal legislation through the CARES Act, because it's mostly going to taxpayers, so it is sort of in sync with tax returns, other than if people are on Social Security and don't file. So they're basically using the records of the IRS and the Social Security Administration to administer these payments. My understanding is that they're not going to. I'm not exactly sure about if you owe back taxes and you already were going to have a refund. What's going to happen there? I don't know that will change any. But let me put it this way: I do understand that what I've heard is that like the $1,200 is supposed to come to you if you're under $75,000 gross income, and it's $2,400 if you're married filing jointly. I don't think they're going to seize that or take that or reduce that because of taxes you owe. My understanding is, they're not going to hold that up. That's just going to go to people regardless. So if that's the question, I think that's the answer from what I've read. I mean,
Thank you, Dan. So
we can hope. We can hope.
Yes, and also remember that this one is informational only. If you have specific questions for one of your cases, you should contact the legal aid assistance. So they will tell you, they will give you the answer or give you more information according to what is the case.
Why don't we go ahead, because I think we don't want to infringe further on LCBH. Why don't we let them start? And I've got the screen up. I think I'm manually moving the screen for them. So I'm ready to manually move the screen for you guys at your command.
Okay. Thanks, Dan. So this is Aileen. Welcome. Thank you for tuning in. Daniel, thank you so much for that awesome synopsis of what happened with that CARE Act this afternoon. That was over 800 pages, so that was really nice of you to kind of boil it down. And yes, it passed this afternoon, so I think we can be confident that that's what's going forward. Again, welcome. My name is Aileen Flanagan. My colleague Sally Robinson will also be joining in. We're going to switch back and forth, but we're here to give sort of an update about how COVID-19 is going to influence tenants' rights. Dan, can you advance the screen? Thanks. So the Lawyers Committee for Better Housing is our nonprofit agency that Sally and I work for. They were founded in Rogers Park in 1980. Oh boy, that's not a. So that should have been cleaned up a little. Sorry about that, folks. But we have a basic mission that believes all persons have the right to safe, decent, and affordable housing on a non-discriminatory basis, and we help people by providing direct legal representation, individual and public advocacy, and we have a supportive services department that can assist people with case management. And today we're here to provide some community outreach and education. So can you advance, please? Thanks. As I said, today we're going to talk a little bit about the recent response to COVID-19, the changes that happened with law and policy that is going to affect renters. We're going to do a review of the regular eviction process, kind of a baseline discussion. Then Sally will go ahead and discuss a little bit about the government actions that have impacted this process. We'll talk about the issues that tenants are facing outside of the eviction process and what steps can be taken, and best practices in this uncertain and ever-changing environment. So, okay, go ahead. So to start with, we'll kind of do a little overview. We have different jurisdictions and then different protections in those jurisdictions. The federal, state, county, and municipal laws all apply to us in different ways. And to know which rule applies, we're going to look at the preeminence of the federal law, preempting all state, county, and local laws where those laws would expand protections. Where the protections are greater at the state, county, or local level, the federal law will step aside and those greater protections will be applied. So it's important for us to understand that when we're looking at which laws affect us in which ways. Our response to COVID-19 have been implemented at all levels of government with differing impact. And the next chart that I've included, if you'd advance the slide, is sort of an overview of the kinds of laws that have been impacting renters for a long time. So I've highlighted a few of those impacting recent changes, but essentially this is kind of the baseline. If you could go forward. And yeah, thank you. So let's talk about what the eviction process looks like generally, and then we can kind of expand on how this has been affected by these different orders that we're hearing about. To terminate a tenancy, it must be terminated only with a predicate notice, meaning they have to serve you, the landlord has to serve a notice terminating the tenancy. That gives them the right to then file an eviction complaint. The notice to terminate has to give the reason for the termination and a waiting period before the eviction complaint can be filed. The waiting period for non-payment of rent is 5 days in Illinois. So they need to give you 5 days, and in that 5 days you can cure. Once that time period expires, the eviction complaint can be filed, and depending on the reason for the filing, if they are two different types of cases that are filed. One is a single action where the landlord is seeking only possession. If the landlord is seeking rent damages, they must file something known as a joint action, and you'll know the difference when you look at the case as it's posted on the public docket sheet. The next thing that has to happen is the tenant needs to be served a summons. That's the notice that comes from the sheriff that tells the tenant about the complaint, tells the tenant for the reason for the case, and tells the tenant where to go to court so that they can go and defend the case. Then the complaint proceeds forward in court, resolving by a dismissal, a trial, or settlement. Once the trial is held, an eviction order can be entered if the judge finds that the landlord has made their case and the judgment of possession is entered in favor of the landlord. In some cases, the court will do something called issue a stay, which means basically they're going to give the tenant some more time to remove their possessions before the sheriff can be sent out. Once that occurs and the stay is expired, the enforcement happens only by the sheriff. So enforcement can't be conducted by the landlord himself. Okay, next slide. Now this is where Sally is going to step in and talk about how some of these actions have, by court and policy, have changed the way this process will go and influence the timing. So Sally, I'm going to pass this on to you now.
Aline, before we get Sally on the call, I would like, there is a big question here, and actually it's about landlord that all my tenants says they are not paying rent, and some of them is still working and getting paid. So he can issue the 5 days notice.
So that is going to be influenced right now as of the effective date of the CARE Act. So I'm not sure what the effective date of the CARE Act will be. It was passed this afternoon. And if the landlord has a federally backed mortgage, he is going to be precluded from issuing that notice of termination of tenancy during the next 120 days. He cannot file an eviction case for non-payment of rent during the next 120 days if that landlord has a federally backed mortgage pending against the property. If he's taken a mortgage out and it happens to be federally backed, I think that discerning what type of mortgage you have is something that you can do by taking a look at your mortgage document. And as Dan said, there are websites you can go to see if you have a federally insured FHA. But I think most properties, if the landlord lives there, are going to be federally backed, and they'll be subject to this moratorium.
But if the landlord doesn't have any, doesn't have the foreclosure, or they don't have any problem with the property, but the tenants right now, they are saying that they don't want to pay rent, so the landlord cannot do anything. He cannot issue the 5 days notice. Even the tenants right now are working because of this new act.
So I understood the CARE Act to say that tenants, I'm not sure if they are going to be required to provide evidence of the impact of COVID on their abilities to pay rent. It doesn't appear to me right now that that's a requirement that the tenant demonstrate how they're impacted. My understanding is there is an automatic moratorium on taking action against tenants during this period, and there is an automatic moratorium on taking action against owners of the same type of dwelling, these federally backed mortgages. I think. So I believe that mortgage forbearance, even if the landlord does not seek a mortgage forbearance, they are still subject to this moratorium for their tenants.
Okay, thank you, Eileen. So let's put on the line Sally, and we can just have more time at the end if people want to wait for those answers. Thank you.
Thanks, Sally. Off to you, and maybe you want to amend anything I've said if you feel that there's more to contribute there.
Sally? Yeah, I think we have lost Sally at the moment. So Eileen, if you don't mind, maybe answer.
Sure.
Yeah, thank you.
Sure. So Sally's not here. Okay. Sorry, everyone. So at this time, there is no bar in Chicago for serving rent demands. That 5-day notice that we were discussing in Chicago. Chicago does not have a ban. The city and the state do not have a ban on serving termination notices. However, buildings with federally backed mortgages may be additional protections preventing the service of this notice, like we're talking about, right, is this Coronavirus Aid, Relief, and Economic Security Act, known as CARES. It appears, and the last thing I read was the bill as it was sent to the House today. I don't know if it's been amended, but as of what I read 2 days ago, multifamily properties that are covered mortgage-backed, which would include low-income housing tax credit buildings, cannot file non-payment-based evictions for 120 days or charge fees for non-payment, and cannot give 30-day non-renewal notices until after the 120-day period. You also can't file actions during this 120-day period to evict, irrespective of whether the landlord is obtaining mortgage forbearance. Cook County is still accepting filings of any lawsuit as far as other properties are concerned. So if there is a property that is not subject to CARES, in other words, it's not a mortgage-backed property, Cook County is still accepting those filings. You can advance. So currently, eviction proceedings are currently being addressed by two court orders. There is a general court order handed out by Judge Evans stating all civil matters not deemed an emergency by the parties are postponed for 30 days until the next business day after 30 days. So it's 30 calendar days and then the next business day. Emergency requests in civil evictions will be permitted, and agreed emergency and all other civil matters will be permitted. So if there's an emergency action filed, that would be heard in eviction court. Discovery in civil matters will continue as planned, and there, as Dan mentioned, there are different administrative orders for the Law Division and the Chancery Division. And as Dan mentioned, those are on the clerk's website. I realize that we are talking to an audience of professionals in multiple jurisdictions in the state. Unfortunately, my and Sally and Dan's operating jurisdiction is primarily Cook County. So unfortunately, we're kind of limited to what we are speaking on in that regard. So check your clerk's website and see if you have additional information. Important to recognize that right now for the next 30 days, no eviction orders or foreclosure orders will be entered, nor will they be enforced. And so that's by order of the Cook County clerk, the chief judge, and the sheriff. So it seems that everything is currently set to expire on April 17th, but you want to keep aware of changes in that. So how do you look up your case? If you think your landlord might have filed a case against you, most counties in Illinois do provide online dockets. In Cook County, it's at cookcountyclerkofcourt.org. In order to do this, you can just go through this slide step by step, and you can look up the defendant's name and find out if a case is pending against you. You can do this for foreclosure as well, and rather than checking the selecting civil division from the drop down, you would just select Chancery. So you can go forward. So I would just look at this to help guide you through that step-by-step process to look up a case. So COVID-19 additional changes to the eviction process. Governor Pritzker has an emergency order in place. This is that shelter in place and requires that all state, local, and law enforcement are instructed to cease enforcement of orders of eviction for residential premises. So essentially, they're all in the same kind of enforcement mentality where everything's being stopped in terms of enforcement of orders. The governor has not precluded anyone from filing cases. He has just ordered that no eviction for residential premises will be enforced. That particular emergency order expires on April 7th. I suspect that April 7th emergency shutdown may be continued and expanded, but we have to wait and see. The Office of the Cook County put a halt to evictions for 30 days, so we expect that to expire on or about April 17th. And then again, the clerk of court, or the chief judge has also extended 30 days from the original date. all matters are scheduled for the court are postponed for 30 days from the original court date. So if you're looking at a court hearing that is scheduled you have an appearance scheduled before April 17th, it's going to be extended by 30 days, but automatically. And as I believe postcards are being distributed, as I think Dan alluded to. So a couple of questions. What if I've already agreed to move out during this period of shelter in place? Because of the shelter in place order, it may be impossible to comply with an agreement that you've already made to move out. If it is a court-ordered agreement, you should notify the other side in writing that because of the shelter in place order, you will not be able to move. I think you should probably try to arrange for an alternative agreement with the other side and keep trying to locate a new place to go and pack so that you can be in compliance when this shelter in place is lifted. So there are talks about rent strikes, and there are talks about people not paying rent and rent freezes and mortgage freezes. So to address the concern of the landlord that was raised earlier in our conversation, there is no current rent forgiveness, mortgage holiday, or any pending or suggested action by any federal or local government or any policy to forgive the obligation to pay our mortgages or to pay our rent. There are some organizations and efforts underway calling for tenants to be forgiven rent, and some calling for smaller landlords to be forgiven mortgage payments. Tenant advocates have to be clear that without any law forgiving or waiving rent or mortgage for any period of time due to the health crisis, the current halt on eviction orders enforcement of evictions does not halt the accrual of rent claims or the filing of eviction cases, with a few possible exceptions. So even if there is a temporary stay on filing cases, it will be lifted. And all of those obligations, mortgages and rent, will be due. Dan, you said maybe they won't be due immediately, but tenants will be subject to some kind of a notice period to cure, and then they will be required to pay or be evicted at the end. So if people are not paying, they should be saving. If people are able to pay, they should be paying to avoid the accrual of these kinds of debts that would happen at the end of this moratorium. So right now, we believe this 120-day moratorium on taking legal action to dispossess people will end. Those financial obligations will survive, and people will be possibly having late payments will be waived, but certainly at this point, no one has proposed waiving the obligation. So cautious and conservative recommendations are to pay if you can, and if you cannot, you will have 4 months to accumulate your funds so that you can pay your rent at the conclusion of the moratorium. So let's talk a little bit about other renters' issues. Renters are sometimes subject to lockouts, utility shutoffs, and payment problems, harassment, domestic violence, returning citizens, and issues affecting tenants with disabilities. So I unfortunately can't speak to the disabilities issue too much, other than to suggest that if you're a tenant with a disability, that you would contact whoever your landlord is and advise them of issues you're experiencing, and that should be treated as emergency housing issues if you need assistance. If you can advance the slide. So what is a lockout? Generally, lockouts are changing of locks, plugging locks, removing doors, removing windows, shutting off utilities, removing property, or making the property uninhabitable. Next slide, please. If this happens, there are a couple of steps people should take, and they should make these efforts now even at the time of shelter in place, especially at the time of shelter in place. We're concerned that lockouts will be the method of addressing disputes that landlords have with tenants rather than following processes which are put on hold. We're concerned that lockouts will start to become more common. Tenants have the right to call the police. You have to be present at the premises if you call the police because of a lockout. Ask the officer to arrest the landlord for failing to end the lockout. If the landlord is unavailable, ask for the police to create a police report. If the officer isn't helpful, you can ask for the beat sergeant or the watch commander and inform them of a Chicago Police Order, Special Order 93012. That order is one of the handouts that you'll have as part of this program. It applies, of course, to the Chicago Police Department, but can also be informative and helpful if you are assisting people who live in different municipalities. Just kind of refer to that and reflect on that when speaking to the department, and maybe they will assist. You can swear out an arrest warrant at the precinct officer to have that particular landlord arrested, and then refer to an attorney because the tenant may be able to sue the landlord for the action. Next, please. Thanks. So where the police refuse to assist the tenant in the midst of the lockout because they believe it to be outside their authority, the tenant and the advocate can refer them to that order. I've also provided the website where you can get that order. It's either at the police department, or you can also get it on the LCBH website, which is www.lcbh.org, where there are other tenant resources. Thanks. So utility shutoffs and harassment. So intentional utility shutoffs by a landlord is a lockout. Tenants can contact the local police department because in Chicago, a utility shutoff is considered a lockout and can be handled the same way. Other forms of harassment, such as improper entry or repeated and unnecessary entries, can also be handled the same way. I think you can contact your local police department and advise that the landlord is abusing the shelter in place and shouldn't be granted additional or excessive entry just to harass a tenant. Next slide, please. So what are some of the remedies that a tenant would have if these evictions occurred? A tenant can file an emergency petition with the court. You can get assistance filing petitions in Cook County with CARPLs or other legal aid agencies. At this time, it's going to be difficult, although we can still file complaints. It may require appearances in court, and there are reduced court staff right now, so the process might be very slow and cumbersome. Contact the police department for some of these actions, and you can always contact local legal aid for help with a cease and desist letter to notify the landlord of the illegal conduct. Sometimes this is done when landlords don't really know what they are not allowed to do, and you can notify them that they're subject to fines, damages, and fees, which can be quite hefty if the tenant prevails. Next, please. So utility disconnection, I think that Dan talked a lot about this, so I'm not going to spend a lot of time, but the government had requested that utilities stop disconnections during the public health emergency. The Illinois Commerce Commission and then provided an order stating that they will be suspending these disconnections during this emergency until 5/1 or until the crisis has passed. But certainly until 5/1, they have to work with tenants, and after they've the disconnection period is over, they need to work with tenants and provide flexible credit and credit options. And ComEd and Peoples Gas have already agreed to comply with this. Thanks. So economic assistance is available to tenants in a couple of places in Chicago. Rental assistance is available through the court-based relocation assistance in my office and also through the Department of Human Services. And in any case, you can access this rental assistance through 311 in Chicago. applying for unemployment assistance and SNAP assistance is also located here, so you can help people find those resources. Next. So domestic violence is certainly a problem. The governor addressed the problem of domestic violence, and those experiencing DV are not mandated to shelter in place. There's a help number for victims to please contact that number. And this is a pretty broad stay in a safe place or a safe alternative place if they need to leave. Thank you for, yeah. So I apologize for a lot of the tiny print here, but I know you'll get a copy of this, and if you have follow-up questions, you can certainly reach out to us. But there are very big concerns about people who are where there are released detainees because they are deemed highly vulnerable to coronavirus. So there is a people being released to seek housing and shelter with family members. They may be subject to private and subsidized guest policies. So they may be limited in where they can go and how they can seek shelter, which can be very troubling to families trying to welcome their loved ones home again. The private market, you would look to your terms of your lease and house rules. Typically, the lease may dictate who can be occupying the premises and how unauthorized people can become authorized and get permission to live in the place, in the premises after be put on the lease. And guests can be limited to visits of no more than 2 weeks at a time. If the lease is breached on the grounds of occupancy by an unauthorized occupant, the tenant is still entitled to a 10-day notice for the breach of lease, which allows 10 days to cure, and the landlord would have to file an eviction proceeding to evict the tenant on that ground. During this period of time, you cannot issue any kind of notice to vacate if the property is subject to the limitations because it is a federally backed mortgage lien on the property, or federally backed mortgage is held to the property. So that will influence how quickly a landlord can take action. And the time to cure that may be expanded at the conclusion of the 120 days. But at this time, if people are looking for guidance on how to manage loved ones that are returning from the Department of Corrections, then they should review their lease and see if there are some options to have a guest, contact their landlord, and see if they can put their the loved one on the lease. If the property is located in Illinois, they are subject to some fair housing requirements that will require that not all people with criminal convictions can be systematically excluded from the property. It's kind of a ban-the-box policy. The same is true in Cook County, and there are specific guidelines on how applicants need to be treated if they're seeking to be placed on a lease or seeking housing and have a criminal or an arrest record. CHA is slightly more specific because they have policies about adding people to leases and policies about guests. We would recommend tenants facing any kind of termination with regard to CHA properties contact Legal Aid Chicago. And if you are looking to add people to your lease, contact Legal Aid Chicago to make sure that you are able to do so if you're a subsidized renter. Next. Oh, I think we're done. So we do have a new app called rentervention.com. This is a step-by-step chatbot that will help tenants work through problems that they're experiencing and will get put into a network of pro bono attorneys if they need pro bono assistance. Otherwise, letters can be populated and all kinds of assistance can be provided to those tenants. So I think that is a good place to start. They will also be referred into LCBH if there's something that LCBH can help with. You can see both mine and Sally's email address is located here, as well as our website. So please feel free to reach out to me if I have been unclear about something, or if you'd like some more information about things that I've touched on. I'll turn it over to questions now.
Thank you. Thank you so much, Eileen. Yes, I just, the majority of the questions right now are regarding, I think you just explained it again. There is no rent free, there is no foreclosure, or like you have to pay. You don't live, you don't rent it for free. So right now, at least it's in Cook County or in the whole state, I just want a clarification about that. You have to pay the rent if you own the rent, that's it, right? And the landlord can submit the 5 days notice if the tenant is not paying the rent.
So let me back up a little bit.
Yeah, please. Because
landlords, yeah, this is really quite confusing, and you'll have to bear with me. We're just digesting this material as it's coming hot off the presses. So we're trying to assimilate multiple sources of protections for people out there, anticipating lots of problems that are going to pop up. So with that little caveat, my understanding of the current federal legislation that just passed today is that for the next 120 days, so during this period, it's called the moratorium period, landlords may not file non-payment cases against tenants. They may not. They may not seek to vacate.
I mean, right. They can pass the notice, but they don't need to, they cannot file on court. They cannot file the eviction.
They cannot serve a notice for the next 120 days, cannot issue, they cannot issue any notice requiring the tenant to vacate. So they cannot give any tenant, any termination notices during the 120 days. After the 120 days passes, they may issue notices for no less than 30 days to vacate. So I don't know, but it strikes me that this may be an additional amount of time for the tenant to pay rent and secure. But I don't want to get ahead of myself, okay? So let's just deal with the next 120 days. Mm-hmm. If the landlord owns a property that is subject to a federally backed mortgage, so if a landlord owns a property that is subject to a federally backed mortgage, there is a 120-day moratorium on filing a case against that tenant. For the next 120 days, they cannot issue a notice to vacate.
But if I could jump in, is that okay? Yeah. Dan here?
Yeah, please.
I think
please.
One of Aileen's points that she's trying to make is a very important one. Just because you can't be evicted during these next 120 days, it doesn't mean you're not going to owe the rent at some point. So if you're not paying the rent all along, on day 121, if there's no further amendment to the law, the landlord could turn around and say, okay, 120 days are up. I'd like to have the last 4 months rent. And if the tenant doesn't have that, then they can be evicted. Again, as far as we know, unless something changes. And so I think that's why she's saying it's better to pay the rent if you can. Mm-hmm. If you can't, try to save it. And then I guess, plan C would be, try and figure out how to deal with it if you can't do either of those two things in 120 days.
And at the end of the 120-day moratorium, landlords may seek to terminate tenancies with no less than 30-day notices. And that means that if they try to terminate a tenancy for non-payment of rent, the federal government may have stepped in and altered the Illinois Eviction Act by saying now it's not a 5-day notice, it's a 30-day notice. So there may be more time to cure. But that remains to be seen and thought about. So pursuant to Dan and my cautionary tale, tenants should be well advised to during this period, pay or save what you can, because the payment is still accruing. You can't accrue late charges during this period, but the payment, the obligation, continues and persists, just like the mortgage does. There may be a forbearance, which doesn't mean a waiver. A forbearance means we'll wait for a little bit, but we still want our money.
Delay. You know, and I think the policy perspective from Washington is, in part, you know, all this relief that's going out, you know, from this federal legislation and through other avenues, you know, I suppose is intended to try to help people, at least partially, make up for some of the income they may have lost, along with like unemployment payments. So, you know, I think that's kind of the way policymakers are looking at it in general.
Thank
you.
I have another question.
I actually need. I don't. If you don't have any more questions on homeownership, I actually have to run. If you have one more on homeownership, I could probably do one more question, and then I'll need to run.
Okay, so we have more questions, but what we can do, because of course we just passed the time, is what about, guys, I will send you the questions and we are going to send the answers of all of those questions while we summarize the concerns that you have. Because Daniel, one of the questions is landlords can still raise the rent within those 120 days. People is confusing right now with that period, but thank you, Eileen, for the clarification. When you say if you it's no waiver, it's no free rent, it's like a kind of forbearance. We just put that one as the foreclosure clients, but they need to pay the rent because they are living there for 6 months and they have to pay the rent at the end of those 6 months, 120 days. They have to pay the rent anyway.
Right.
And it's better if they can. It's better 1 month than 4 or 6 months. Yeah, together.
Right. So, Vivian, if you could, I like your idea. If you could take questions, like assemble all the questions that we haven't had time to answer, and between us, Eileen and I can answer them, and we can get those back to people. Because I
definitely
need to go, and I think I'm in control of the screen here, so I have to turn it off. But also, what I would say, and I'm sure this is true for Eileen too, is you can also email me directly. My contact information was at the beginning, and I guess you'll get those PowerPoint slides from Vivian. But I'm happy to take questions, you know, emails directly as well.
Yes, thank you so much, everybody. We are going to answer all of these questions. I'm going to forward to the experts. Thank you so much, Legal Aid Chicago, Daniel. Thank you so much, Eileen and Sally, that unfortunately she couldn't connect as well. But all of you guys, we keeping in touch. Visit our website, and promise you that we are going to send you PowerPoint handouts recorded and the questions answered by our experts. Thank you and have a good afternoon.
Thank you.
Thank you,
everyone.
Bye-bye
Stay
now.
safe. Bye-bye.